Hello friends, Namaskaram. How are you? Myself is Dr. Jinesh Soni. In today's class, we will discuss about Section 356 of BNS. Are you having any idea? So simply, we could say that if someone is going to defame you, he could be prosecuted as per law of defamation because defamation is also a crime as per Section 356 of BNS. But simply or in general way, filing of litigation is not sufficient. We have to specify in which manner the concerned accused defamed us. If our submissions are general, there is no specification. In that scenario, the prosecution could not be succeeded. In the similar way, if you are the accused and you are facing a false case of criminal defamation and the ingredients are not satisfied, and apart from that, the allegations are general, omnibus, non-specific, inconsistent, and there is lack of corroboration, then we could have the benefit. So, in simple words, first of all, we have to understand what Section 356 of BNS is. Are you having any idea? If you're not having any idea, just note down the concept and then we will discuss a case so that you could easily understand about a criminal defamation. For example, if someone says you have committed a theft, but in actuality you have not committed. So what he has done, he has defamed you because inter alia he submitted an information which is false from the inception. But the information is true. In that scenario, that person could not be prosecuted. So basically, by the said example, it is quite clear that the concerned allegation must be false, so that your image has been outraged in the eyes of esteemed people of the locality. If the basic allegation or if the primary elements or ingredients are missing, then we could have the benefit. I'm going to specify you one of the most important judgment of Honorable Guwahati High Court. That is 4th of Feb 2026. In that case, it is specified that to constitute the criminal defamation, the allegations must be specific and the role of the concerned accused must be specific. If both the limbs are absent in that scenario, the proceedings of criminal defamation is liable to be quashed. And apart from that, we are having judgment of Honorable Jammu Kashmir High Court, that is 7th of Feb 2026. Although it is a case for the stay, but the court specified that the magistrate is bound to hold the inquiry as per section 223 of BNSS if the opportunity of being heard is not given to the concerned accused. In that scenario, the proceedings are abuse of process. So the present case, which I'm going to discuss with you, is the outcome of Karnataka High Court verdict, that is 23rd of Jan 2026. In that case, the concerned accused had been prosecuted as per section 356 of BNS, and inter alia, the cognizance has been taken by the concerned court. In that case, the petitioner submitted that the present case is nothing but abuse of process because it is submitted as a counterblast. The concerned accused inter alia initiated the proceeding against the complainant. So, with intention to refrain him, with intention to cause panic to him, inter alia, the present case is lost as a counterblast, and that's why the proceedings are nothing but abuse of process. In addition to this, in a defamation case, I am asking more specifically about a criminal defamation. The inquiry as per section 223 and section 225 of BNS is quite important. If the concerned proceedings are not going to be supported or going to be evidented with section 223 or section 225 of BNSS, in that scenario, the proceedings would be illegal. And apart from that, no FIR could be registered, more specifically in case of criminal defamation. Regarding the questioning, two important judgments we have to observe, and both judgments are pronounced by Honorable Supreme Court. Judgment number one, citation is 1993 SCC Criminal, page number 149. In that case, it is observed that the judicial process must not be used as an instrument. In addition to this, the citation of judgment number two is 1998 SCC, page number 749. In that case, it is observed by Honorable Supreme Court that summoning of accused in a criminal case is a serious matter. Criminal law cannot be set into motion in matter of course. So, if the allegations are non-specific or general and without any consistency or corroboration, then we could have the benefit. But we have to remember in our mind that the opportunity of being heard is must. If the opportunity of being heard is not given in that scenario, we could have the benefit. And apart from that, section 2 to 3 of BNSS internally incorporated the provision to make the prior hearing quite mandatory. So basically, in that case, the Honorable Court quashed the matter and inter alia remanded back the matter regarding the fresh adjudication. So it is quite clear to us to constitute a criminal defamation, a specific role of the accused must be on the record, and apart from that, the due compliances is required to be shown. If there is no due compliances, the Fed is not going to suggest any inference regarding the violation of law. In that scenario, we could have the benefit. So I specified you the modus and the way in which you could proceed and effectively submit your stand so that you could have the effective remedy from the court.